Supreme Court justices are considering now whether to temporarily block the abortion ban while it works its way through the courts.
As you can imagine, it is a contentious issue getting a lot of attention nationwide. WLKY's Mark Vanderhoff was in court today and details both arguments.
Inside the courtroom here, both sides made their cases and were questioned by the justices, while outside, abortion rights supporters loudly protested the state abortion ban. The chants could be heard during the Kentucky Supreme Court hearing Tuesday morning.
The Attorney General respectfully urges the court not to go down that path and not to create the Kentucky version of Roe versus Wade. When it comes to abortion, our Constitution here in Kentucky is simply silent.
Abortion clinics are asking the High Court to temporarily block two laws: the so-called trigger law, which bans abortion except when the mother's life is at risk, and a separate ban on abortion after 6 weeks.
I think that if the court is going to read an implicit right to abortion in, you have got to have historical evidence, and there's none at all from our constitutional debates.
Well, counsel, let me ask you. First of all, I think everyone would agree that history reflects there were no women. There were no women at the 1890 Constitution. Women did not have the right to vote.
The hearing also comes 1 week after Kentucky voters rejected Amendment 2, which would have changed the state constitution to explicitly say there was no right to an abortion.
I understand the importance of the representatives, the people in the General Assembly that we elect, but it strikes me that a ballot initiative is the purest form of democracy.
The ACLU argued Jefferson Circuit Court Judge Mitch Perry was justified when he first issued an injunction temporarily blocking the abortion ban.
Patients' irreparable injury includes being forced to remain pregnant against their will, facing physical and mental health risks and the pain and trauma of a birth they did not choose, or taking on the additional cost, time, and hardship to travel out of state to access abortion care if they are able to at all.
Even if the justices do block the two laws that are being challenged here, there would still be a state law banning abortions after 15 weeks. In Frankfort, Mark Vanderhoff, WLKY News.
All right, Mark, and there is no timeline for the justices' decision. The case goes back to Jefferson Circuit Court once they decide whether or not to block the law.